On Law Weekly today, we continue our assessment of the judiciary 59 years after independence. We look particularly at some of the challenges facing this all-important arm of government. We talk with the former president of the Commonwealth Lawyers Association, Mrs. Boma Alabi. We also have the views of some lawyers on what the judiciary can improve on in the new legal year, plus our weekly recap of the top trending stories of the courtrooms. Hello and welcome to the program. I'm Shola Shuyeli. We continue our assessment of critical issues confronting the judiciary 59 years after independence. My guest, Mrs. Boma Alabi, is the cross-border solicitor and officer of the Order of the Niger OON, who is passionate about judicial reforms, the protection of human rights, particularly women and child rights, as well as replicating global standards here in Nigeria. On this episode of the program, I began by getting our assessment of how well the judiciary has fared since independence in 1960.
Well, I'll start by saying, when we talk about the judiciary, people tend to think of judges because that is what it is. But it's not just about judges, it's a whole justice system. And our justice system is a system of injustice. Our criminal justice system is a criminal system. Look, I took the word justice out of it. It's a criminal system.
Without the justice.
Without the justice. And why is that so? Because everyone is a victim. The judges are victims. The lawyers are victims. The accused person, the complainant, the police. The system doesn't work. And because it doesn't work, it doesn't deliver justice. Despite the hard work of the judges, you have to move. Okay, think about the process. If you charge someone to court, if they're in detention, for instance, they have to be brought to court from wherever they're being detained. If the vehicle is not fueled, which often happens, and they're unable to be brought to court, the judge is sitting there, there's not much he can do. The lawyer representing the state will be there, defense lawyer will be there, the case cannot move ahead. If a police witness is supposed to come along to court and give evidence, so the investigating police officer, for instance, the state is supposed to provide him with transport money to get to court. In most cases, that doesn't happen. So he either has to use his own money, as poorly paid as they are, to get to court, or the Ministry of Justice will have to find a way to get them to court because they want to move along with that case. That's not fair. That doesn't work. In some cases, because we have a federal system, the investigating police officer has started and concluded an investigation. By the time the matter goes to court, it's a year later. He's been posted from the state of the incident to a different state entirely.
And he has to come from outside.
He has to come from outside jurisdiction. He has to find transport money, or the state has to find transport money. That's not a fair system. These are the things that cause delays in the courts, as a result of which there's no justice for the accused person, no justice because there's no closure for the complainant, no justice for the judge whose time has been wasted, no justice for the lawyers whose time has also been wasted because they've turned up in court ready to proceed only for one of these logistics challenges to stop proceedings. That's why I said it's a criminal system. And we have to find a way to make it work better. It requires more resources, and those resources must be given to the justice system in order for it to deliver. More resources to the judiciary, more resources to the police, more resources to the prison service, more resources to the State Attorney General's office. Those resources are within the gift of the state. The only thing that is controlled by the litigant is the defense lawyer's fees. So we really need to pay more attention to this system, give it the resources it requires to work and deliver justice.
Yeah. You talked about resources, but the budget has just been laid by the president before the National Assembly. Do you think that it would help or change anything?
There's been no difference as far as the justice system is concerned. Good news, more money for education, which is in dire need of it. But the justice system, or the criminal system that we call a justice system, is in dire need of resources as well.
We had elections this year, and the elections brought with it a lot of petitions and cases to our courtrooms. What for you has been the impact of the elections on the justice system? Because you talked about the courts being already overburdened and all of that, and now we have more cases coming in. And what has been the impact for you?
This is something that only if you're within the system and you're caught within the system, you realize how dreadful it is. I'll give you an instance. Real life cases that we're dealing with where, a petition for a divorce, not contested. Both parties are living separately and have been doing so for over 6 years. As you know, it's a 2-year separation, and that's it. In a normal year, that should really have started and concluded within a matter of 6 months. Because this is an election year, all the judges, not all, but the majority of the judges in the state high courts and so on, have been swept out of the normal courtrooms into this election petition tribunal. If you think about it, there is no such thing as an election petition tribunal in the sense of a building or judges who are specialist election petition judges. They are taken out of this already overburdened system in order to deal with the election petitions, pre-election matters, and post-election within the time that has been provided by the law. That is a bad law in the sense that it doesn't take the citizen into consideration. The system is already overburdened. The judges are then moved into these election petition tribunals, and all the litigation that deals with the lives of ordinary citizens, their marriages, their businesses, commercial transactions, those who are charged with criminal matters who are awaiting trial, are effectively put on hold for the year. So if I was a Nigerian and I had to do anything in court, I would have to avoid the election year because nothing will happen.
Talking about the impact of the timeline of the election petition cases, you say that it's a bad law. Do you think that there's a need to retweak or reconsider the laws, and how?
Absolutely. I mean, we have, I believe, a bill pending at the moment. If not, there should be. And we must take the citizen into consideration when they amend the Electoral Act. What is the impact of this, timeline? Because all the judges have to focus on those petitions to the detriment of citizen litigants who are not involved in election petitions. How can we ensure that we meet the objective of the election, the act, whilst not impacting negatively on the citizens? And it's not rocket science. In other jurisdictions, in England, for instance, they have part-time judges who are in practice. And so we could bring something like that into the mix to deal with that peculiar situation only, so that in the election year, perhaps, it's one solution, one that I'm proffering. It doesn't necessarily have to be the best one, but we have to look at it. Maybe senior lawyers, maybe registry, I don't know. But we must find a solution that ensures that the citizen has access to the courts and their matters are not delayed because of election petitions.
Who has the responsibility for doing that? The NBA in partnership with the lawmakers?
I think when these bills are taken to the National Assembly, they should consult more widely. They must consult all stakeholders before they eventually pass such a bill into law. Because the danger of not consulting is what we have seen, which is that they forget the interest of the most important person on the table, which is the citizen of Nigeria. The stakeholders, all these politicians are servants of the people, and they're supposed to put the people first. They haven't done so.
Staying with issues of challenges in the judiciary, one area which a lot of people have issues with the judges and senior lawyers like yourself is in the area of legal technicalities. I remember that when the Chief Justice of Nigeria was being screened by the Senate, one of the questions that came up was how the Supreme Court under him would handle technicalities, coming from lawyers and even from the judges. A case that comes to mind is that of the judgment of Osun State, where because the judge was not on the panel, there were legal technicalities which resulted in the judgment. But many Nigerians think that it's time to do away with the legal technicalities and do justice based on the cases. What do you think?
Again, that is why we have this criminal system. Because where we are is where England and Wales was in 1850 something. And this is 2019. We can take another 150 years to progress to where they are now, because this law that we practice came from them. Or we can fast track by putting in place rules and regulations, procedure, and if necessary, law that will fast track us to where the courts are dealing with the substance of the matter rather than the rules of engagement. Majority of our litigation is around, like you say, technicalities. We're litigating the margins. A lot of cases start and finish without getting to the substance of the case. It reminds me of a Charles Dickens novel, Bleak House, The Bleak House. It's 1850 something, he was a court clerk, so he knew how that system worked or didn't work, which is exactly what we're dealing with here in Nigeria. We need a situation where, and it's in the gift of the Chief Justice of Nigeria actually, because procedure is from the court directions. And once that direction says, you know what, interlocutory issues, you can't appeal them until the substantial issue is dealt with. That would take a lot of these interlocutory appeals that hold up cases from proceeding, and therefore justice is denied. It will take that away. Nigerian Supreme Court is as busy as a magistrate court. The last time I checked, which was, they're dealing with hundreds of cases in each quarter. That shouldn't be the case. That's the apex court of the land. Only constitutional matters or things of such importance should be brought before our Supreme Court justices. We're taking interlocutory matters all the way to the Supreme Court. That should not be happening.
I want to round off with the issue of sex for grades and the viral video that we've all seen now. The Senate is proposing a sexual harassment bill, which, well, did pass the last assembly but was not assented to by the president. And they've made some provisions like stipulating 5-year jail term and all of that. What do you think? Do you think that we need a new law?
Well, firstly, I would commend the Senate for saying, look, this is an issue that should come to the front burner. But in my view, that law, thank goodness it didn't pass, because it proposes 5 years imprisonment or 5 million naira for any lecturer convicted of sexually harassing or having intercourse with a student under the age of 18. 5 years imprisonment. At the moment, they could be in prison for over 5 years.
Based on the laws that we already...
As they stand. I prosecuted a case for one of the states with the fiat of the Attorney General. It was a rape case. I achieved a conviction, and that rapist was sentenced to 25 years in prison. So why should they get 5 years? Why not 25 years? Why not life? So that bill should propose a minimum of 5 years and a minimum of 5 million. Leave the upper limit to the discretion of the judge so that justice will be properly served. If that is the proposal in the bill, then I'll support it. If it isn't, then I don't think it's good enough and they should go back to the drawing board.